Hi, I'm Ifeoma Odulami. I'm an immigration attorney with the Odulami Law Firm in Morristown, New Jersey. There's several humanitarian pathways to getting a green card, and today I'm going to talk about one of them. I'm going to talk about VAWA. VAWA is an acronym for Violence Against Women Act. However, men and children can also apply under VAWA. VAWA was passed in 1994 by Congress to protect victims of domestic violence who have a relationship with a U.S. citizen or a green card holder. And the protection that VAWA offers is that the victim can do what we call a self-petition. They can self-petition for a green card for themselves without requiring the participation of their United States citizen or green card relative. And basically what it is that Congress recognized that requiring the participation of their relative actually creates a situation which is worse for somebody who's a victim of domestic violence. So basically what it means is that as a VAWA petitioner, you can apply for a green card, you can self-petition for a green card, and your relative does not need to know that you're applying for a green card. And there are steps being put in place to prevent them from getting that information to protect your application. So people who are victims of domestic violence can be assured that they can make this petition without incurring the wrath of their relatives. Now, who is eligible for VAWA? The abused spouse, men or women of a U.S. citizen or a green card holder is eligible. The children of the abused spouse who are under 21 and unmarried are also eligible as derivatives. Another category is children who are under 21 and unmarried of a U.S. citizen or a green card holder. They can also self-petition. Now, there are situations where those children do not file for petition until they're over 21. The law allows them to file for a VAWA petition late if they're between the ages of 21 and 25. They just have to show that the abuse occurred before they were 21 and that the reason they filed late was as a result of the abuse as well. A third category that can file is the parents of a U.S. citizen who is over 21. Now, I just want to back up a little and talk about the definitions of a child in a VAWA petition. Now, a child has to be under 21 years old. A child could be your biological child, it could be a stepchild, it could be an adopted child. Now, if it's an adopted child, that child must have been adopted before they were 16 to qualify to file for VAWA. If it's a stepchild, that the marriage that led to the relationship of the relationship of being a stepchild must have taken place before that child was 18. So those are the conditions under which a stepchild or an adopted child can file under as a child for VAWA. Now, the other question, the other thing we're going to talk about is what qualifies as abuse. There's this misconception that to qualify for VAWA, you have to show that you're being physically abused, and that's not correct. There are different types of abuse. There's physical abuse, there's emotional abuse, there's sexual abuse, there's financial abuse, there's verbal abuse, and there's psychological abuse. Immigration law recognizes different types of abuse. And like physical abuse, what evidence do you show? And I'm only going to give you examples because the list is quite inexhaustive. For evidence of physical abuse, you can show, if you have it, a police report, medical reports from a doctor. You can show restraining orders or affidavits from family and friends who have either witnessed or that you've talked to about the abuse, social workers, the clergy, and all that. Now, you can also show emotional abuse in forms of humiliations, threats of reporting the victim to authorities about her immigration status. Sexual abuse, an example is forcing the victim to have sex physically, or threatening them to make them have sex, or putting the victim at risk of STDs, or denigrating them sexually. Those are just examples. Examples of financial abuse could be denying access to family income, refusing to allow the victim to work, or forcing them to work so that they can support the relative, forcing them to quit a job, restricting them from job training or going to school. Those are examples of financial abuse. Examples of verbal abuse: name calling in person, sending threatening texts, sending threatening messages, constant humiliation privately or in front of people. Psychological abuse could be using the immigration status of the victim as a form of abuse, threatening them about it to tell the immigration authorities, isolating the victim from others, keeping tabs on their every move. I mean, there's a lot of things that immigration law has recognized to be abusive behavior. So just because your relative is not hitting you does not mean that you don't qualify under VAWA. You want to talk to a lawyer about that. Now, as a VAWA petitioner, you must show good moral character. And if you're married to a U.S. citizen, you have to show, or a green card holder, you have to show that the marriage was bona fide, which means that it was not entered solely for the intentions of immigration benefits. You also have to show that you've lived with with your spouse for some period of time. The law doesn't really indicate how long, but some period of time has been found to be enough. And the important thing is you don't have to be living with your spouse to file for VAWA. So this is just a little capsule of VAWA, and there's a whole lot more that goes into determining whether someone qualifies for VAWA and presenting a solid case so that the petitioner can self-petition under VAWA. If you feel that if you think that you qualify for VAWA filing, or you want to know more about VAWA, please feel free to call my office, 973-993-1900.